and thank you everyone for participating in this important Zoom call today. We're excited to introduce Luke Meisner. We try to do this, I don't know, 2 or 3 times a year, give a trade update via this platform. But before I introduce Luke, I want to address an issue that I know is on a lot of your minds. And I've received a lot of questions with respect to the special dues assessment that Ben Kim sent out about 2 weeks ago. And I will say that the board of directors of the KCMA, many of which are on this call, really worked hard to try to figure out how to minimize the impact of these special dues to your companies. Let me just say that KCMA has spent in excess of $7 million over the last few years on this trade case, and you all may or may not know, our annual income is about 2.5 million. So you can see how this has put a major strain on our organization. I would guess that most of you over the past 3 or 4 years have realized the benefits of this trade case. And as you know, as I just said, these cases are very expensive, and it's imperative that we not let our guards down, not right now. We are moving into a critical time in our trade cases and the various litigation that we have going on that Luke will speak about. He'll also outline the fact that at every turn, whether we file petitions or the respondents file petitions, China is always involved in these activities. They're always opposed to whether it's a review or rebuttal comments, or they appeal to the Court of International Trade. So they are watching us very closely. I will say that they certainly have the capacity to reinvigorate their cabinet manufacturing operations. They have workers, they have lax environmental controls, so many ways that they can undercut our market and come back if we don't continue our fights. And that comes with the need for additional funding. If we cannot collect the $3.5 million that we need to in the next 3 years to fund the case, especially leading up to the sunset review, we may well be in a position that we have to drop our cases. Luke will talk about what happens at the 5-year review, which starts in exactly 2 years from now. And that essentially is a mini AD/CVD filings all over again, which comes with a much greater cost to the KCMA. So I'm happy to answer questions at the end if anyone has questions. I'm hoping that as we go through this afternoon, you'll have a greater understanding of what it is that we're trying to do, and the importance of the work that the KCMA and the great help of Luke Meisner, our trade attorney. So put chats in the chat box if you have questions for me and for Luke as we move along. So with that, we have a lot to cover. Luke, I'm going to turn it over to you. Most of you know Luke Meisner. Luke is a partner at the Schagrin Group here in Washington, D.C. I will say that he is one of the best trade attorneys that there is here in the district. So we're very blessed to have Luke. And Luke, I'm going to turn it over to you so you can get us started.
Betsy, that's a very generous introduction. And yes, it's been my honor to represent the U.S. domestic cabinets industry over the last several years. And I consider it a privilege today to be able to present to you an update on all the work that we've been doing on behalf of the industry, and to be able to interact with you all today. So we do have a lot to cover. I'll start by saying all the opinions I'm expressing here today are our law firm and do not necessarily reflect those of the KCMA. Quick overview of everything we're going to cover. First, I want to remind everyone, especially as Betsy was discussing the special assessment that's been raised by the board, of the impact of the trade cases, the beneficial impact of the trade cases, what the industry was going through before the KCMA brought the cases, and what the industry looks like after relief was provided in the form of anti-dumping and countervailing duties, or AD/CVD. I'm then going to pivot to talk about the ongoing efforts that we've been involved in to keep the AD/CVD relief strong. And there's a large variety of efforts that I'll get into there. And then finally talk about some of our efforts to combat evasion of the AD/CVD relief, including investigations we've brought with Customs and Border Protection, as well as a really huge piece of litigation that we've brought over the last year or so involving countrywide scope and circumvention inquiries for imports of cabinets from Malaysia and Vietnam. So let's dive in. First, we'll talk about the original cases on imports from China. And I want to focus on, again, what was happening in the industry in the U.S. market before the cases were brought, and then what the picture has looked like after we won the cases. And I think you'll agree with me when you review everything that filing and winning the trade cases really rescued the domestic industry from an all but certain demise. So I'm going to go back and to start, looking at what the industry looked like before the cases were brought. Going to highlight some of the findings that were made by the U.S. International Trade Commission back in early 2020, when it reached its final determination that the domestic cabinets industry had been materially injured by reason of Chinese imports. First, if you look at the volume of Chinese imports, the ITC found that there's a massive increase from 2016 to 2018, continuing on to 2019, of cabinets from China. That increase did not just serve an increase in demand, it was way beyond any increase in demand for cabinets, meaning that the Chinese were taking market share away from the domestic industry. No surprise that the ITC found this. Chinese imports were underselling all of you guys. They looked at 120 comparisons of Chinese prices to U.S. prices, looking at the same style and types of cabinets. In 115 of 120 comparisons, the ITC found that Chinese cabinets were significantly priced lower than the domestic cabinets. And as a result of this, again, no surprise, this meant that the domestic industry, when it needed to raise prices to cover increasing costs, whether it be in terms of increased costs for raw wood, lumber, labor, energy, the Chinese producers were preventing price increases by the domestic industry that they needed to make, which was resulting in a price cost squeeze and, in terms of impact, declining performance. We talked about lost market share, but the domestic industry's production and financial performance started off generally steady between 2016 and 2017 because there's a huge boom in consumption or demand for cabinets, but it all started to catch up with domestic industry in 2018 and 2019, which saw dramatic declines in performance. And wages and workers, that's another metric that the ITC measures. And again, in terms of total hours worked, the number of workers employed by the industry, they all started going down in 2019, right? Which is why these cases were filed. So how about impact of the trade cases on imports? This is a chart that shows, well, at their peak, Chinese cabinets were coming in to the tune of $160 million a month. That was in late 2018. After the cases were filed, you see there's an immediate dip or decline in imports from China. And by the time the final AD/CVD orders were imposed in May 2020, China has basically exited the U.S. market, and there's been a even continued slow gradual decline to I think they're now coming in at about $1 million a month is what we've seen for the most recent import statistics. So we think about it, 160 million a month down to 1 million a month. That's a huge impact. Now here you can see, this is a graph that shows what's happening with Chinese imports versus the rest of the world. And you can see that there was a good deal of replacement in the beginning from countries like Vietnam and Malaysia. But over the last year, we've really been battling transshipment and circumvention from those countries. And you can see that there's a general decline taking place over the last year, even from imports from the rest of the world. Another way of looking at this is to say, okay, well, this red dashed line shows what was happening with imports before the cases were filed. And if no cases had been filed, if you just let that dashed line continue at the same trend that it was before the cases were filed in 2019, that's what the dashed line shows. The blue shaded area underneath shows actual imports of cabinets into the United States. So the difference between the dashed line and the blue shaded area is the benefit that the U.S. domestic industry has received in terms of keeping unfairly traded imports of cabinets out of the U.S. market. And if you tally it all up, that's $4.9 billion of imports kept out of the U.S. market. I will note the total would probably be higher than this, because this does not include vanities, wooden vanities, or cabinets components. It's harder for various reasons. The U.S. official statistics don't measure vanities and parts or components as accurately as just straight up cabinets. So this is just focused on the cabinets. Even then, we're looking at $4.9 billion of benefit from 2019 to 2022. So dramatic beneficial impact. And we hear, a lot of this is confidential. So, I can't give you all the details, but I think you'll probably a lot of you have experienced this in your own companies. Keeping China out created the kind of environment that allowed the domestic industry to invest in itself, meaning new production facilities, upgrades of equipment, and other enhancements to existing production facilities. There's been, probably tens, if not hundreds of millions of dollars of new investment in the U.S. cabinets industry since the cases were won. So even though there's been this great beneficial impact, after the cases were won, a lot of people think, well, that means it's all over. We can ride off into the sunset. It's a happy ending, Hollywood movie style. Well, unfortunately, that's not the way it works, because the Chinese producers have not thrown in the towel. They're continuing to try to attack the U.S. market in a variety of different ways, including appeals in the court system, administrative reviews of the dumping and subsidy rates that were calculated by the Commerce Department at the end of the investigations, requests for scope rulings, evasion tactics such as transshipment, and circumvention of the orders by having finishing operations in third countries like Malaysia and Vietnam. And so I'm going to try to get through all of those today and talk about this. Is since the orders were in place, and this is really where Schagrin Associates stepped in, and where all the work that we've been doing on behalf of the KCMA and the domestic industry has taken place. So before we go in, I do want to quickly take one last granular look at import statistics and highlight a couple of things. So yes, so Vietnam, you see in 2019, before the cases were won, that entire year, $50 million of cabinets were imported from Vietnam. quick rise. By 2022, you're looking at $880 million worth of cabinets. So Vietnam is a country we've really focused on to the extent that they're still shipping Chinese cabinets through Vietnam one way or another. We're trying to take care of that. And you can see in 2023, we've made some pretty strong progress. Imports are actually starting to decline from Vietnam. They're down 13.62%. Another country, Malaysia, 2019, $49 million worth of imports from Malaysia. By 2022, that had skyrocketed to 325 million. Now, unlike Vietnam, where there is a significant deal of legitimate production, we always knew Malaysia was just rife with transshipment and other evasion. And so we've tackled that very forcefully. And you can see that showing up in the import statistics as well. In 2023, imports from Malaysia down almost 50%. So going back to the other battles we've had with China. So first is the court appeals. After the cases were won, the foreign producers and the importers have a right under U.S. law to appeal to the U.S. Court of International Trade. They filed 3 cases challenging various aspects of the affirmative determinations of dumping and receipt of government subsidies from the Chinese government. I have those listed up here. Won't get into all the details, but I think it's suffice to say that for the appeals of the original investigations, we are still on track for victory in all 3 cases challenging Commerce's final affirmative determinations. I'll quickly mention also that there's a 4th case out there. In the first administrative review of the orders, we got a high 251% rate against this one company, Dalian Hualing, that's been trying to enter the U.S. market. Dalian has appealed that case to the CIT, and that actually just got underway this year, and we're still in the middle of briefing. Administrative reviews. Administrative reviews are a very important part of the life cycle of anti-dumping and countervailing duty orders. So the idea behind the review is, it's possible that the Chinese producers and the Chinese government can change their behavior in response to the imposition of relief. So they might stop dumping, the rate of dumping might go down, they might stop, the Chinese government might stop providing subsidies to the Chinese cabinets producers. And so they have a right to request a review of the AD/CVD rates once every year. And this is like a completely new investigation that Commerce will conduct of the foreign producers. It's none of the original information that was gathered during the original investigation is used. It's a completely new sales and cost information. And these reviews are very important to stay involved in because they can, if the domestic industry doesn't stay involved and make sure that the rates stay high, it can really vitiate the relief from the orders. And that's because the new rates that are calculated by Commerce in the review have 2 impacts. First, the new rates apply retrospectively. So we just got, the Commerce just initiated the 3rd annual review of the orders earlier this month, as a matter of fact. And so that means Commerce is going to look at imports that came in over the past year, from 2022 to April 2023. And when it does that, the U.S. importers may have had to pay a certain high duty rate. For example, a lot of them were paying 38% dumping duties, for example. They had to pay that in cash to U.S. Customs and Border Protection for every import that they made of Chinese merchandise. Now, if they ask for a review and Commerce recalculates the rate and it recalculates it at 0, then all that cash that they paid over the last year to the government, they receive back in return. And we don't want that to happen because it basically sends a signal to them that they can just continue to import from China without repercussions, without there being a level playing field for the U.S. domestic industry. The other thing that happens is that those new rates that are calculated apply prospectively going forward. So if before they were having to pay 50% in cash or 38% in cash for every import, if the new rate is zero, that means they pay zero dumping duties for every single import of Chinese cabinetry. So very important to keep these rates up. So we're in the middle of the third review now. We're technically in the middle of both the second and third review. But I'll quickly go over all of the reviews that we've been litigating. So the first review on the subsidy side, these are subsidies provided to the Chinese producers by the Chinese government. August 2022 is when Commerce issued the final results. There were only four Chinese companies involved, and the rates basically remained largely unchanged. We have the preliminary results of the second review that came out in May of this year, and the rates were roughly 7 to 14, 15%. So for some companies it went up, for some companies it went slightly down, but overall we kept the rates strong. The third review was just initiated just several days ago, basically. And one thing I want to highlight here is that there were 43 Chinese companies that requested a review of their rates. That means there's at least 43 companies out there in China who don't like the rates. We see their imports from China have gone down virtually to zero, but they're trying to re-enter the U.S. market by lowering the rates that are in effect for them. So that's on the subsidy side. On the dumping side, first review was a little rough. We received the final results in November 2022. We got high rates for 4 Chinese companies. We did get 0 rates for 16 companies, which was really a travesty. But because we kept up the fight in the second review and already got the preliminary results back up, I think we've shown to the Chinese industry that the domestic industry is not backing down. We're not giving up. And you can see that reflected in the import statistics where, the Chinese have not resumed shipping cabinets, dumped cabinets back into the United States. So the second review, we got the preliminary results last month. High rates ranging from 7.7 to 43%. We're feeling really good about the second review. We think we're going to at least keep those rates as high as they are in the final results, which will come out this fall. And we even have a couple of opportunities to increase them. And again, a couple of days ago, Commerce initiated the third review of the dumping order. Here, there were 69 Chinese companies that have requested a review and are trying to reduce their dumping rates. So very important that we stay involved and engaged in these proceedings. Scope rulings. So the scope of an order basically is what defines which wooden cabinets, vanities, and components thereof are subject to the duties, because not all cabinets are subject to the duties. If a cabinet's made out of metal, not covered. If the cabinet is freestanding and is not for permanent installation, like the kind that are in most kitchens or in vanities when it comes to bathrooms, not covered by the scope of the order. That's the basic contours, although of course, since we lawyers wrote it, I can tell you the scope goes on for several pages trying to make sure it's airtight. That being said, the Chinese producers and some U.S. importers, they're always looking for some hint of ambiguity or some loophole in the order that they can exploit to resume shipping Chinese cabinets to the United States. So this is another area where it's just critical to continue fighting, continue the battle, and make sure that we do not allow any loopholes to be opened up in the relief or in the orders. So this next chart this just shows all the different scope requests we've been battling since the orders came into place. I will say, sometimes there's legitimate ambiguity and people just want to figure out, well, is something covered or not? So actually that's the case with one of the first scope rulings requests that we received. It was a company called Homeworks that was importing medicine cabinets. And we worked with them to make sure that Commerce understood, okay, medicine cabinets were never something that was intended to be covered. We've had other beverage centers imported by Disney for its hotels down in Florida. We worked with them to make sure that there was a proper ruling. So these are some of them. There's one scope ruling in particular that I want to highlight today, which I think probably represents the greatest threat to opening up a huge loophole in the scope of the orders. So this came out February of this year. A Chinese company called K-Ling filed a request saying, hey, Commerce, we make these cabinets that are made out of phragmites, and we think they're not covered by the order. So will you please look at all the evidence we're submitting and agree with us that these phragmite cabinets are not covered? So you might look at this and think, well, what in the world is a phragmite cabinet? And so phragmites are basically another scientific name for the common reed. I've got a picture of it up here on the screen. And you might be able to notice that they have pretty thick stalks. The stalks have a ligneous material, a woody material. And so how is this company K-Ling making cabinets from this? Because you might think, well, why should we care about this? I mean, there's no way any of my customers would ever be interested in a phragmite cabinets. First of all, it just sounds terrible. So what kind of cabinets yours? Maple. How about yours? Phragmite. I can assure you that's not how they're going to market it. So how do they make cabinets from this? They take the phragmite reed stock and they chip it up, and then they mix it with glue and compress it to basically what they're doing is they're making MDF with these phragmite materials. They might coat it with melamine. And then this is a picture, apologize for the poor quality, but this is a picture provided by K-Ling itself of cabinets that were made with phragmite. So you can see, maybe this isn't the highest end kitchen you've ever seen, but if you made that white and you made some modifications to it, it would look like a lot of the cabinets that a lot of you on this webinar sell every day to your customers here in the United States. So they're basically trying to figure a way out to sneak cabinets in without paying the duties. And their argument is, well, reeds are not wood. Wood means maple, birch, cherry. Phragmites are reeds and not wooden. And so that's their argument to the Commerce Department. So we've been, our position, which we've been arguing and submitting evidence to Commerce to, is that, well, if you read the scope of the order, it does say that wooden cabinets includes cabinets made from engineered woods, like particle board and MDF. And any boards that are made from phragmites would be classified as particle board or MDF, which is wooden, based on the definition of the scope that was drafted. And so cabinets made from phragmites are wooden and should be covered. So that's just an example of of another battle we're fighting against the Chinese on these scope rulings. Another huge effort that we've been involved in is anti-evasion. So one thing I'll say about everything we've covered so far, I mean, at least these importers and Chinese producers are doing things above board. They're litigating in the courts, they're litigating in front of the government agencies, but at least they're doing it in a transparent way. Evasion is different. This is actually illegal activity, where they're trying to get Chinese cabinets in without paying the duties, sort of, in an illegal way, to put it bluntly. I mean, and there's different ways they can do this. They can misclassify merchandise. It's a cabinet, but they call it a chest of drawers or something like that. They can undervalue it. If it's a $300 cabinet, they can declare that it's $50. And so they only pay the 50% duties on $50 instead of $300. But by far, the most common method that we have seen is transshipment, where they ship cabinets from China to a third country like Malaysia, put it in a new shipping container, call it a Malaysian cabinet, ship it to the United States, and then don't pay duties on it. So one tool we have to address this is filing an allegation with Customs and Border Protection under the Enforce and Protection Act, or EPA. And I'm going to highlight one of the cases that we've won with the Customs agency somewhat recently. So this was, a somewhat sophisticated operation where you had Chinese cabinet factories that were linking up with a Chinese individual named Huang Jianmin. Now, Huang Jianmin was, enterprising. When he saw the orders came out, he said, "Hey, I've got a good idea. I'll set up my own logistics company, that can arrange for all the shipping of all these products. And I'll set up a bunch of warehouses in Malaysia." There were at least 3 that we were able to identify: LLWF, MSW, and South Wales Furniture. And I will work with U.S. customers and the Chinese cabinet factories to, I'll be a one-stop shop for transshipment. You come to me if you want to buy Chinese cabinets. I'll arrange for the shipment from China to Malaysia. I'll have it in a warehouse. It'll be repackaged, and then I'll send it to the U.S. customers. And we filed 6 allegations against these companies listed over here to the right: Unitile, Durian, et cetera, et cetera. We won preliminarily in 2022, and then we had a final determination last year. Then they went through a review process internally at Customs, and in February, we got a final determination. And so what happens is, this means that all these importers are going to have to pay all the duties they owed on the tens of millions of dollars of cabinets that they imported, and they could be subject to other fines and penalties as well by Customs. So that's evasion. There's a lot of other evasion cases that we've worked on, but I won't get into every single one. I'm just going to highlight this one. So next, I'm going to turn to some of our efforts on the scope and circumvention inquiries. And this has probably been, over the last year, one of the biggest projects we've worked on. We filed a request in April 2022 that Commerce initiate scope and circumvention inquiries. We're basically looking at imports of cabinets from Malaysia and Vietnam. And the target is imports of WCV, or wooden cabinets and vanities, that are comprised of a mix of Chinese components and Malaysian or Vietnamese components. And I'll tell you a little bit. It gets pretty complicated, so I'm going to try to walk you through exactly what we're talking about at the 30,000 foot level. So here I've got, a simple diagram of what a basic cabinet looks like. So what's happening, what we learned through a lot of research and investigation, and hearing from tips from people like you, people that are on the webinar call today, is that a lot of Chinese companies were setting up shop in Malaysia and Vietnam. And what they were doing is they're continuing to make the doors, the drawer faces, and the frames in China, send those components to Malaysia and Vietnam. And in Malaysia, Vietnam, they would have a factory that could make the boxes, the cabinet boxes and the drawer boxes. And they would combine all those components together in Malaysia and Vietnam. and then shipped the complete package to the United States with a declaration that says this cabinet is from Malaysia or this cabinet is from Vietnam, without declaring that some of the components were made in China. And our position is that those cabinets should be covered by the AD/CVD orders, because as you know, the boxes are the easiest thing to make, generally speaking. It's the doors, the drawer faces, and the frames that are the hardest to make and really impart the sort of essential characteristics of the cabinet, and where a lot of the value added and cost of the cabinet come from for a variety of reasons. So that's, you know, sort of the target of these scope and circumvention inquiries. Again, it gets a little more complicated because there's different scenarios involved, and I'll talk a little bit about that. So, you know, one scenario is you know, they're taking fully finished doors, drawer faces, and frames made in China, and then combining that with fully finished cabinet and drawer boxes made in Malaysia and Vietnam. Another scenario involves semi-finished Chinese components. So they might take doors, drawer faces, and frames that have been assembled together into subcomponents, but not stained or painted. They send that to Malaysia and Vietnam, do the staining and painting, and then combine it with the other components. Finally, the last sort of important scenario that we're asking Commerce to look at is parts of components. So we're talking about basically the rails, stiles, and the panels of the doors and the drawer faces and the frames. Those are made in China. Those are shipped to Malaysia and Vietnam, assembled into the components, sanded, painted, finished, and then combined with the other components before being sent to the United States. And this is going to be the toughest one to win. I think we should win. The evidence is on our side. The scope language is on our side. But you can understand the position that's being taken by some of the importers and the producers in Malaysia and Vietnam that, well, there's so much actual manufacturing operations taking place outside of China when you're doing the assembling, the sanding, the painting, and all this, that these are no longer Chinese components or cabinets. There's so much value added that has taken place in Malaysia and Vietnam that the cabinet has been substantially transformed from a Chinese cabinet into a Malaysian or Vietnamese component. So that's kind of the lay of the land and what we're fighting here. But as you can see, even though we're going against imports from Malaysia and Vietnam, we're really still fighting China, because you know, I firmly believe most of the value add, most of the important manufacturing is still taking place in China. So, and those Chinese companies are still receiving the subsidies and all the benefits that they get from the Chinese government and operating in China. And so I think it's just vital to keep these imports out. We got the preliminary results of the scope inquiry in March. We won the first scenario, which I mentioned, which covers finished wooden doors, drawer faces, and frames. Commerce basically said there's insufficient information to cover the other scenarios. So we've submitted additional information, and we're waiting for Commerce and briefing and legal arguments, and we're now waiting for Commerce to reach a final decision. As I said, it gets a lot more complicated. I've got some more detail here on what's going on, and you guys will have the slides if you want to dive in more on what's happening in the scope and circumvention proceedings. So because they've been so complicated, Commerce has extended the deadlines for the final rulings quite a bit. I think they will not extend it anymore, but right now the final scope rulings are due out in August and circumvention not until November. So, you know, let me talk about one more thing before I get to the key takeaways, because this is not on the slides, but but Betsy had mentioned it, and I do think it's important to talk about. So every 5 years, under U.S. law, both the Commerce Department and the International Trade Commission have to conduct what some people call a sunset review, or a 5-year review of the orders. And this is basically a decision they're making as to whether to continue the orders and the relief for another 5 years, or to revoke the orders. And like Betsy said, this is a huge, can be a very huge legal proceeding, kind of similar to the original investigation, where company executives may be required to come and testify before the commissioners here in Washington, D.C. as to why the relief should be continued for another 5 years. There'll be questionnaires potentially issued to the entire domestic industry, questionnaires issued to the Chinese industry as well. So it's a huge process, and basically we have to show two things. At Commerce, which is not that big of a burden, we have to show that if the orders were revoked, the Chinese would continue dumping and shipping subsidized merchandise to the United States. That's typically not the hardest part. The hardest part is winning at the commission and showing that if the orders were revoked, the domestic industry would return to a state where it was being injured by imports and would not be able to thrive again. So that's going to take place 5 years from when the orders were first issued. So again, that's going to be 2025. But it is a huge piece of litigation and will take quite a bit of legal. So that's the sunset reviews. Before I turn to taking questions, I want to go over just sort of some key takeaways that I want everyone to have and walk away with at the end of this webinar. First, the KCMA as an association has to be commended because it has been so strong in its commitment to ensuring that the domestic industry can compete on a level playing field against unfairly traded imports from China. I truly believe, I've been practicing international trade long enough to have seen countless American industries go by the wayside because they've been attacked and decimated by the Chinese government and Chinese producers. So these cases are really a lifeline to the domestic industry. In fact, by our calculations, the orders were kept out over $4.9 billion of unfairly traded imports over the last 3 or so years, saving American jobs, communities that those jobs support, and encouraging new investment in the cabinets industry in our country. Now, Chinese producers, again, they have not thrown in the towel. They know that the United States is the largest and the most open market in the world. It is the prize market. Everybody wants to gain access to and sell into the U.S. market, and the Chinese certainly have built their whole economy around that strategy, with the help of government subsidies and other kinds of support from their government. So they are still interested in attacking the U.S. market. They're doing it through various legal maneuvers, which we're fighting. They're also doing it through illegal tactics like evasion and transshipment, and we're fighting them on that battlefront as well. And if we cannot give up the battle. We have to keep up the efforts to ensure strict compliance. If not, the domestic industry is going to return to a very vulnerable state and could, like many other industries in this country, just be absolutely decimated and wiped out. So that is a key takeaway that I want everyone to leave with, and open up the floor to questions now.
Hey, Luke, can you just briefly mention President Trump's 301s?
Yeah, so the 301 tariffs, as you know, so there's also 25% tariffs from Trump's 301 tariffs, which were imposed in 2018. Those have also, in addition to the AD/CVD duties, those have played a tremendous role in keeping Chinese cabinets out. And it provides a little bit of a cushion because, you know, like a rate of 7% by itself, there's some companies, Chinese companies, are subject to combined AD/CVD rates of, you know, 100%, 50%, 80%. That by itself is enough to keep them out. There's a handful of companies that maybe have combined AD/CVD rates of, let's say, you know, 7%, 15%, 20%. That by itself would slow them down, but maybe not keep them out entirely. But the Trump's 301 tariffs add on to that and are also a tremendous help. And this is another thing that we've been working on, submitting evidence and comments to the U.S. Trade Representative to urge the U.S. government to keep those 301 tariffs in place. They're still in the middle of a review. There's by law, there's a 4-year review of the 301 tariffs. They're still in the middle of that right now. Just as a matter of politics, I can't imagine anyone letting up the gas on you know, our efforts to combat China's unfair trade practices. But you know, the political winds blow this way one day and they blow another the next. So it's important to keep that pressure on and make sure the 301 tariffs stay in place.
Thank you, Luke. The only other thing that I will mention is that you all are probably thinking, how, you know, will this go on forever? And for those of you that were at our spring conference in Destin Beach, Florida, heard from Wyatt Bassett. They just finished their fourth 5-year review. And in the early days, the first probably 4 or 5 years, 6 years, they spent a lot of money, time and effort, had, you know, lawyers working on it. And after, I don't know what he said, I think it was more like after 7 years, slowly those imports not only were increasingly less coming into this country, but also he has seen now that in these out years, they spend more like 100,000, because what he suggested is they've moved on to, you know, greener pastures and are not as focused on furniture, bedroom furniture anymore. So, you know, there will be an end to this at some point where, you know, it fits very nicely into the KCMA budget. But I think we're still a few years from that. So I just want to mention that. And then we should, Luke, open it up to questions from the group.
Yeah, Luke, there's a couple questions I have here. Excuse me here. One is asking, this is a lot of observation work. Do you have boots on the ground to observe this activity?
We do. We do. So, you know, sometimes we get tips from folks like you all on the webinar that you've seen something or heard something, and we follow that up with as much desk research that we can. But sometimes, you know, you can find out a lot on the internet. Sometimes you actually have to go over to those countries and figure out what's going on. So a couple of times we've used, you know, budget to hire a private investigator to put boots on the ground in these countries. We've done it in Cambodia, Malaysia, Vietnam, a variety of different countries to see what's going on there. We also, you know, we have contacts now. We've built up contacts, especially in Vietnam. So we have sometimes, you know, through that network, we can also figure out what's going on in those countries. But boots on the ground is definitely a very important tool that we do employ in our anti-evasion efforts.
All right, and then the next question, is there an updated list available of the Chinese companies suspected of evasion? and any related companies / customers?
Well, that's an interesting question. We don't have a comprehensive list, no. That's an interesting idea that maybe Betsy and I can discuss. But they're all suspects in my books. But if I had to, maybe put some on a red list versus a yellow list, that would be an interesting project. But I mean, there's so many. But I will say this. So one of the things we're trying to get at through the proceedings from Malaysia and Vietnam is a certification process where Commerce will be able to look at the companies that are shipping cabinets from Malaysia and Vietnam and create a list of those companies that have been green lighted and are eligible to participate in a certification process that allows them to ship cabinets here without paying any duties. And then other companies that are on a bad list, or maybe you're not eligible to certify, and if they try to ship cabinets from Malaysia to the United States, they would have to pay duties on those cabinets as if they're Chinese merchandise because they've not shown that they have legitimate production operations in that country. So that is one of the goals, is to be able to clean up the supply chain, create transparency in the supply chain. Because look, there's legitimate producers in Malaysia and Vietnam and other countries. We don't want to stop them through these proceedings, but we do want to stop the ones that are evading and circumventing the orders.
And then, Luke, speaking of transshipping, the question is, there's been a huge increase of this kind of activity coming through Mexico. What are the plans to investigate or stop that?
Yeah, Mexico's definitely on the watch list, 100%. We've really been focusing on Malaysia and Vietnam because they came up so fast first, but we've certainly noticed that Mexico is probably up next in line. But it's one of these situations just like Vietnam. You start looking at the companies that are supplying with the tools that we have available, and some of them look like, yeah, they're legitimate producers. They set up shop in northern parts of Mexico after the orders went into place, and they seem to be making cabinets in Mexico and sending them here. On the other hand, is that just a disguise? Are the pictures on their website fake? Are they doing what some of the Malaysian and Vietnamese are doing, where they make half of the components in China and half of them in Mexico? So that's something we're definitely taking a look at with respect to Mexico.
I would say this, that it would require filing new AD/CVD cases if we got that far, and just realize again that that is a significant undertaking, both in time and money. So the board would have to think long and hard about that.
Absolutely.
Here's another question coming in, saying that we've been fortunate our present federal administration has not lifted the current AD, ACVD, and 301 tariff established by the previous administration. Would an executive order by POTUS overrule the final ITC ruling in March of 2020?
The president does not have the authority to overrule the AD/CVD tariffs. That's one of the reasons we often tell industries that are being negatively impacted by imports that one of the best things you can do is file a new petition, new AD/CVD cases, because if you win, maybe 5% of the calculus of if you win or lose is politics. The rest is the law and the facts. But once you have the orders in place, the president does not have the authority to overturn it. The 301 tariffs is a little different. That came out of the U.S. Trade Representative, which is a cabinet agency that I think the 301 tariffs, frankly, could go away at the snap of a finger. if a deal was struck with China, or for whatever reason the president wanted to get rid of them. Again, I don't see that happening. That's not my prediction, but it's always a possibility.
Luke, so then in one of the questions, and I'll frame it into it with another question, but there's a lot of companies out there, not necessarily KCMA members, that may be benefiting from this, and while still kind of importing from some of these companies. And then a more specific question to that is, China is currently building a very large cabinet plant in Mexico, and I don't know, I'll say this other company's name, but another company is importing from Mexico currently. What are the thoughts on how to deal with that?
Well, I am aware. We've been looking at all the new plants going up in Mexico, so we're definitely aware of that. And I think all I can say in a sort of public forum like this is that we're definitely looking at it, and if we see evidence of evasion or transshipment or circumvention, then we're going to attack it. We're definitely going to go after it. So if anyone here on the call knows of those kind of illegal activity, then please let Betsy know, and she'll pass that information on to me. But right here, as I sit here right now, if they're building a legitimate factory and they're using starting from raw wood materials and building cabinets in Mexico, we can't do anything about that short of filing completely new cases, which is always a possibility, but that's bringing new cases, having to show dumping, subsidies, and injury all over again.
Okay, any other questions, Mike? I don't see any.
Nope.
Well, we have another 2 minutes if anyone wants to ask questions about the dues assessment. Any other questions to Luke? We have still a couple of minutes. We have one more question, Mike.
Yes. What about new cabinet facilities being built in the U.S. funded by China and producing cabinets in the U.S. but subsidized by China, and then their ASP of cabinets will be far less, it'll cost far less to produce?
That's a pretty complicated question. Typically, the domestic industry is happy onshoring. I know, if they're still getting support from the Chinese government, well, that does make it tougher. But if they're bringing their manufacturing facilities here to the United States, they're typically facing the same kind of cost structure that the rest of you are facing, making it here in the United States. So, we'd much rather see that onshoring taking place than having to face a Chinese producer in China. But I do understand the concerns. They could be getting some other kinds of support from China. But at least the trade laws, AD/CVD laws, are not designed to address that kind of issue.
Okay. Well, as Mike said at the outset, the both audio, video, and slide deck will be available sometime tomorrow morning that you can go in and download. And if you want to share with others within your company, please feel free to do so. And with that, it is 3 o'clock. And so again, we thank you for taking time to join us today. We'll do another one of these probably, if not before the final second review is over and the scope and circumvention, we will do it pretty soon after that.
Okay, well, thanks everyone for joining. I appreciate the opportunity to present to you today, and look forward to the next time.
Thank you, Luke.